May I have the appearances, please?
Morning, Judge. Sue Ackerman, Daisy and Zach Waukesha appearing for the state.
Sir, would you please state your name for the record?
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value in return for value all of the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments.
All right, the record should reflect that the individual known to this court as the defendant, Darrell Brooks, is present.
Not identified by that name or consent to being called that name.
So noted. All right, Mr. Brooks, do you have a 13th subpoena? As we discussed yesterday, you wanted to call 13 witnesses. I told you you had until this morning to fill out another subpoena.
Yes, I do.
All right, can you hand that to the bailiff, please? I'll just take a look at it quick. Mr. Brooks, I'm reviewing this for completeness, and you have simply put on here state of Wisconsin plaintiff. That's an entity. You have to name a person.
Any legal basis why that would not be accepted, Your Honor?
You have to have a person named so that they can come and testify.
Is it not true that under the Sixth Amendment I have the right to face my accuser?
Mr. Brooks, let me hear from the state.
Yes, Your Honor, I agree with the court's assessment. The subpoena does not state a person. The subpoena form specifically indicates that the person requesting the subpoena is to indicate the witness's name. Mr. Brooks has simply written the word State of Wisconsin plaintiff. The State of Wisconsin is an entity. It's not a person. The State of Wisconsin cannot testify, so the subpoena should be rejected, Your Honor.
I object to that, Your Honor, on the grounds that every document that was filed in this matter stated that the State of Wisconsin was the plaintiff, which would lead me to believe that the State of Wisconsin is who's bringing the claim against my client. How could they not be subpoenaed to testify if they're the plaintiff? And under the Sixth Amendment, I have the right to face my accuser. My accuser in this matter is the plaintiff, which is the State of Wisconsin.
I'm not going to require the State of Wisconsin to testify.
Are they or are they not the plaintiff, Your Honor?
They are the plaintiff in this case.
And why are they not able to testify, being that they...
Sir, you've named an entity, not a person.
I'm requesting a written judicial finding of fact and conclusion of law on this issue. How can a claim be brought against my client if I'm not able to face the accuser?
I'm not going to explain any further why you can't call the State of Wisconsin.
May I state for the record,
And
Your Honor?
hold on, I'm also not going to issue a written decision.
May I state for the record, Your Honor, I have not even seen a complaint in this matter. There has not been proven that there's subject matter jurisdiction as of yet. There's no verified proof of even a claim, especially if I'm not allowed to face my accuser. I don't understand how you can make that judicial decision, Your Honor. For the record, may I respectfully move for interlocutory declaratory appeal on this matter, Your Honor?
I'm not an appellate court, sir.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction?
Your request is denied.
Based on what law or fact, Your Honor? With all due respect for the record, you're avoiding my questions.
Mr. Brooks, I've addressed the same issues probably every day we've been in court. I know you may be dissatisfied with the response, but my responses stand.
It's not a dissatisfaction, Your Honor. It's a lack of understanding. I don't even understand the true nature and cause of the charges.
You've been made aware of them multiple times.
I do not understand them, is what I'm saying.
I encourage you, if you don't understand anything, to seek the advice of an attorney. I cannot give you legal advice.
I'm not asking for that, Your Honor. I'm merely asking, why are my constitutional rights being prejudiced? It states under the Sixth Amendment that I have the
Sir,
right...
I've already addressed this. Your Sixth Amendment rights are being honored no differently than any other defendant that has appeared in my court.
Have any other defendant not been awarded the opportunity to face their accuser?
You are facing your accuser. Every single witness who's been on this stand, you have cross-examined.
None of those witnesses are making a claim. None of those witnesses are the plaintiff. None of those witnesses are identified as the injured party. An injured party has to make the claim, Your Honor.
Sir, it's my opinion that your belief as it relates to that is mistaken. I've directed your attention once again to the Beneby decision.
Was it federal Supreme Court case?
It's a Seventh Circuit Court of Appeals case. We're in the Seventh Circuit.
But you just stated that you're not a court of appeals, but you're citing a court of
No, but
appeals
Court of
case.
Appeals case law applies to this court. I'm bound by legal precedent from the various courts that are above me.
And you're still not explaining how I'm not able to face my accuser. I'm merely stating for the record that I should be awarded my Sixth Amendment right. The claim has to be made by a living, breathing human being.
Sir, I think you're confusing civil law with criminal law. That's what I'm saying.
No, I'm confusing. I'm not confusing any law. The Constitution says that I have the right to face my accuser. May I put Your Honor on notice that I intend to appeal that decision?
Your statement's noted for the record.
Is
It's
that a
noted for the
judicial
record. I've already addressed it.
Is that a judicial determination? Are you going to answer that, Your Honor? Is it a tacit agreement?
It is not.
Judicial determination should be
The
made.
record should reflect that the jurors are coming in.
The record should also reflect that I received no answer to that question.
Did there come a point in time when you were marching in the parade when something awful happened?
Objection.
Overruled.
Something made me look and think, what was that?
Okay. Something unique, something that wasn't right.
Objection. No witness.
Overruled.
Did the SUV then pass around your husband's truck on the driver's side?
Yes.
Objection.
Overruled. Mr. Brooks, any questions for this witness?
Yes, I do. For the record, I don't consent to that name. You testified that the vehicle came 3 to 5 feet from you. And you also said you weren't able to identify the color of the vehicle. With the vehicle being that close, how were you not able to identify the color of the vehicle?
Objection, argumentative.
Grounds.
Sustained.
Were you able to see a license plate from the vehicle?
I'm sure I would be able to see, but in a state of fear and panic, I wasn't able to register what it was.
So would it be fair to say that because of that same reason is why you wouldn't be able to identify the color of the vehicle?
Correct.
Do you recall giving any police report or being interviewed by any law enforcement? Around the 26th, you recall why it would take almost a week to be interviewed?
Objection,
Grounds.
argumentative, beyond the scope of the witness's
Grounds.
knowledge.
Grounds.
Sustained.
Do you recall reading or seeing a complaint in this matter in any way?
Objection,
Grounds.
Sustained.
Would you consider yourself to be a party to this matter?
Objection,
Grounds.
relevant.
Sustained.
Were you in fact subpoenaed by anyone to testify in this matter? Do you recall by whom?
By the state of Wisconsin.
And when you say the state of Wisconsin, who do you refer to?
Objection, argumentative.
Grounds. Have you had any interactions with the state of Wisconsin?
Objection.
Grounds. Did you have any phone conversations or any physical conversations with the state of Wisconsin?
Objection.
Grounds. Do you even know the state of Wisconsin?
Objection,
Grounds.
argumentative.
Grounds. It would be fair to say, based on your testimony, that you were in fact called to testify by the state of Wisconsin.
Objection, asked and answered.
Grounds. I didn't even finish the question. And I had the grounds on that.
Finish your question.
Seeing as how that you were called to testify by the state of Wisconsin, it would be fair to say that you've actually saw the state of Wisconsin.
Objection.
Grounds.
It's vague.
Grounds. To the best of your knowledge, would the state of Wisconsin be the plaintiff in this matter?
Objection.
Grounds.
Irrelevant.
Grounds.
Sustained.
And I had the grounds for the sustain.
Sustained.
Your Honor, with all due respect, the jury needs to know
question.
this. They deserve to know this.
Next question.
To the best of your knowledge, are you aware that for a case, there has to be an injured party?
Objection.
Grounds.
Irrelevant.
Grounds. As you said, the state of Wisconsin called you to testify. Did they at any time identify themselves as an injured party in this matter?
Objection.
Grounds.
Argumentative.
Grounds.
Irrelevant.
Grounds.
Sustained.
Reason for the sustain, Your Honor?
Continue, Mr. Brooks.
Any reason for the sustain?
It's sustained.
May I have the grounds, Your Honor?
Keep going, Mr. Brooks.
This is information that the jury deserves to know, Your Honor.
The jury is the judge of the facts only, and the court is the judge of the law.
What was your role in the parade?
I was driving the float for Citizens Bank.
Your wife Stephanie works for the bank, is that right?
Yes. Suburban pulling the trailer.
Full-size SUV?
Objection.
Yes.
Okay.
Overruled.
You've driven in parades before?
Yes.
Because you're a good husband.
Yes.
Okay. And
Overruled.
let's show you an item that's been marked as Exhibit 46, please. And we're going to put it up for you first. Do you believe this video is a true and accurate representation of the events as you ran up to Jane on the
Yes.
street? Move to admit 46 and permission to publish, Your Honor.
Objection.
Permission to publish is granted.
My objection be noted for the record, Your Honor.
It's noted.
We're going to go ahead and play it all the way through, 15 seconds at normal speed.
All right, Mr. Brooks, do you have any questions for this witness?
I do. Whew. I apologize. I just needed a quick second. You saw brake lights. Would that be fair to say?
Yes, I did.
To the best of your knowledge, what would be the only time you would see brake lights on a vehicle?
The point right before Jane fell off the hood.
I think you misunderstood my question. Would it be fair to say that the only time anyone would see brake lights would be if you hit the brake?
If the driver hit the brakes, the brake lights would go on the vehicle.
Any reason why you would refer to the driver as he if you did not see the driver?
That would be like the proverbial we.
Well, there's males, there's females.
There are singles and there are togethers. I mean, when you say we, it's the proverbial we.
So
Collectively, he would be along those lines as well.
is it fair to say that you could have just answered as we instead of he?
Objection.
Grounds?
Sustained.
Matter grounds on that?
It's argumentative.
Any reason why you would answer that question as he?
Objection. Irrelevant. Argumentative.
Grounds.
Sustained.
Were you able to get a license plate of the vehicle?
No, I was not. I was focused, like I had said, on the body on the ground.
After the vehicle had passed the vehicle that you were in, did you see the vehicle strike anyone after that point?
I did not see the vehicle strike anyone after the vehicle had passed me, other than driving over, like I had stated, the body that it had already struck.
Did you observe the vehicle strike anyone while it was approaching your position?
Yes, I saw it hit Jane
While it was approaching you?
while it was coming
Or
up.
your vehicle, rather?
Yes.
You said you went into a building called the Nice Ash after that. Do you recall about what time it was at that moment?
No. These are thoughts that you don't think about when you've been through something like this. You know, I didn't sit there and note down times.
Be fair to say from the video that you were shown that it was pretty clear?
Again, wasn't focusing on the sky.
Would it be fair to say you can recall lights coming on, but not the driver of the vehicle?
I think that's asked and answered, Your Honor.
Objection. Grounds.
Overruled.
I can remember lights coming on because they are stationary. The vehicle was traveling past me at a rate of speed with a woman that I thought was my wife on the vehicle. Was not really paying attention to who was driving the vehicle.
So would it be fair to say you were paying attention to the lights?
No.
So what would lead you to believe that they were in fact coming on at that time?
Objection. Argumentative.
Grounds.
Asked and answered.
Sustained.
After you saw brake lights, did you see the SUV ever come to a complete stop?
No.
Objection.
Overruled.
Did you at any time see the driver of the vehicle pull over, stop, and get out to investigate what he or she had just struck?
Objection.
Overruled.
No.
Sir, how old are your children that were at the parade?
Objection.
Overruled.
7, and my youngest was 3. My 7-year-old daughter had her foot ran over, broke 4 toes, and also her tibia and fibula.
Were you able to look at specifically the left shoe after the car went past?
Objection. Leading the witness.
I
Overruled.
recall seeing a tread mark across her shoes.
Do you see yourself depicted in this video?
I do.
I would ask that Exhibit 49 be admitted into evidence and published to the jury.
Objection.
Permission to publish is granted.
Objection. Noted for the record, Your Honor.
It is.
You stated earlier that you saw the vehicle clip the corner. Would that be fair to say?
I saw it clip the corner of where the children were standing.
What do you mean by clip?
Come into contact with children that were in the
Is
front.
that how you would define clip?
That's my definition of clip, correct.
You stated also that it veered quickly away. What do you mean by veered quickly away?
The vehicle at one point was coming straight at us and it quickly turned. Otherwise, it would have come onto the corner.
In your opinion, why would the vehicle have quickly veered?
Objection again.
Grounds.
Speculation.
Grounds.
Sustained.
If you were driving the vehicle and were able at any time to see people directly in your path, would you veer away?
Objection. Relevance for this.
Grounds.
Sustained.
And are the grounds for the sustain?
Calls for a hypothetical that he has not been qualified to answer.
Did you get the license plate number of the vehicle? You see any tents on the vehicle?
No, I was not paying attention to the vehicle after it came down barreling at the children.
So it'd be fair to say that with you focusing on the kids, it would be difficult to describe the vehicle.
Outside of it obviously being a red SUV,
So it'd be fair to say the only thing you can recall about the vehicle was the color of it.
that it was a red SUV, a larger vehicle.
So the color of it.
Correct.
You stated you did the father thing, as you put it, and downplayed the significance of the injury. Any reason why you would downplay it?
Compared to everything else I'm seeing around us, you're in an okay position right now. So I don't know if it was downplaying the injury per se. It's not that. It's okay.
It would be fair to say that the language you used was you downplayed the injury.
Yep, that's correct.
Before the vehicle approached, did you observe anyone being struck?
Yes.
You would estimate the speed of the vehicle to be about 25 miles an hour. How could you come to the determination of the speed?
Because it was barreling right at us.
You're not trained in speed analyzation. Would it be fair? Would it be fair to say that you don't know exactly the speed of the vehicle?
Objection.
Grounds.
Yes, without looking at a speedometer, I would have no way of knowing exactly how fast that vehicle was going.
Have you read or seen any complaint in this matter?
Objection A.
Grounds.
Sustained.
Have you or your wife filed any claims in this matter?
Which claim, define claims?
Being an injured party or anything of that nature?
We submitted a claim with the DA's office, I believe, for potential medical reimbursement for my daughter.
So would it be fair to say that you have a financial interest in this matter?
Objection.
Grounds.
Relevance.
Grounds.
Sustained.
Are you aware of the plaintiff in this matter?
Objection. Relevance.
Grounds. Ever had any contact with the plaintiff in this matter?
Objection.
Grounds. Ever had any phone conversations or personal interactions with the plaintiff in this matter?
Objection.
Grounds. I don't believe that's vague, Your Honor. I asked specifically if there were any phone conversations or personal interactions. I think that's pretty clear.
Sustained.
And I also believe the jury deserves to know if there is a plaintiff in this matter.
Next question, please.
Are you aware if there even is a plaintiff in this matter?
Objection.
Grounds.
Sustained.
May I have the grounds for the sustain, Your Honor?
Relevance.
I would object and say that it's very relevant. Again, citing
Your
that.
objection is noted. Next question, please.
Were you ever contacted by anyone who identified as the plaintiff in this matter?
Objection.
Grounds.
Sustained. It's still vague.
That's pretty clear, Your Honor. The jury deserves to know this information.
Mr. Brooks, the objection has been sustained. Next question, please.
No further questions.
You did not see any brake lights, is that correct?
That's correct.
Objection.
Ground.
Relevancy.
Overruled.
You testified that you observed the red SUV strike an individual to your left, is that correct?
Objection. He also stated that he was focused on his children and not focused on
That's an argumentative statement. What's the legal basis for your objection?
that is hearsay.
Overruled.
After you saw her on the ground, did the red SUV stop?
Objection. Hearsay.
Overruled.
Was there anything that you could see in the roadway that would have prevented that red SUV from stopping?
Objection. Hearsay. Stated he couldn't
The
see
objection to
above that.
hearsay is noted. It's overruled.
Can you ask the question again, please?
Certainly. Did you see anything in front of you that would have prevented the red SUV from stopping?
Objection. Irrelevancy.
Overruled.
Nothing that I saw would have stopped him. That wouldn't have allowed him to stop.
And after he impacted your group and it continued on towards the dancing grannies, was there anything that you could see that would have stopped The red SUV.
Objection. Who's the he you're referring to?
I don't understand the objection. Overruled, you may answer.
Consent to being called he. We don't even know the he that's being referred to.
Overruled.
The witness didn't identify a he.
Overruled.
I'm still appearing by a third party for my client in this matter as a living human being. Also would like for the record to address subject matter jurisdiction again, Your Honor, if you would like to answer that now.
No, I would not and will not.
Is that a judiciary determination? So you will not be answering that. Is that a tacit agreement again, Your Honor?
I'm not answering that.
So is that a yes or no? I'll take that as a yes for the record, Your Honor.
That's not either, sir. I'm not answering
You didn't
that.
reply. Remember, non-response is consent.
Did anyone raise a concern about where they were standing at some point during the parade?
There was another mom there, and she had actually said to me, gosh, they're out a little bit far. And I said, everything's going so slow, they're not going to get hit. They'll be fine.
Did you get medical attention right away?
I dropped my youngest and my oldest off at home, and then I quickly took Owen to Waukesha Memorial.
At one point before the vehicle came through, you were having a conversation to the effect of things were going slow, they're not going to get hit.
I never said I was having a conversation.
Well, let me back up. Who were you talking to when you said everything's going slow, pretty slow, they're not going to get hit?
Another mom.
So would it be fair to say that's a conversation?
Yes.
Why did you make reference to getting hit at that point?
Because I didn't expect my kid to get hit at a parade.
So you had already made the determination that they were going to get hit at a parade at that point?
Objection.
Grounds.
Argumentative, sustained. You do not have to answer that question.
Why would getting hit be in your head at that point?
Objection.
Grounds.
Relevance.
Grounds.
Overruled. She may answer the question.
I wasn't concerned about my children being hit at a parade because typically at a parade floats are going very slow.
It still doesn't quite answer the question because the statement was things are going pretty slow, they won't get hit. What prompted the statement they won't get hit at that point?
Another mom was concerned about how much into the street the kids were waiting for candy.
The initial concern was from another parent and not yourself.
I wasn't worried about my kids getting hit at a parade as I shouldn't have been.
You stated also that you dropped your other kids off before seeking medical attention. Any reason why you didn't seek medical attention immediately?
I did seek medical attention immediately.
You also just stated that you dropped your other kids off. And
My house is on the way to the hospital, so I dropped 2 of my children off so they wouldn't have to sit at the hospital.
So your intention at that point was to seek medical attention?
I sought medical attention.
Was that your intent?
That's what I did.
Was it your intent?
Objection. Argumentative.
Grounds.
Sustained.
Before you were able to see the vehicle that struck your son, or was it your son?
Yes.
Before you saw the vehicle, did you observe anyone else struck before that moment?
No.
After that moment?
No.
Do you recall how long you were treated at the hospital?
I don't know. We were there for a while waiting. The waiting room was full of people that were hurt.
Were you ever told at any point during your waiting process that you probably could have went to another medical facility?
Objection.
Grounds.
Sustained.
You recall giving a statement to law enforcement? Did you follow up on that report?
No, I didn't.
Any reason why?
Why would I follow up?
Well, it would be fair to say, would it not, that after making a report to law enforcement, you would want to follow up maybe to see what's going to be done about the report?
I knew that the police were going to do their jobs, so I didn't have a reason to follow up.
So it'd be fair to say you just gave the report and then just left the rest up to law enforcement?
Sure.
Did you file any claims related to this matter?
No.
Ever read or saw a complaint in this matter?
No.
Grounds.
Sustained.
Were you subpoenaed? Do you recall who that subpoena was from?
I don't know.
You received a subpoena and never read who it was from. Would that be fair to say?
From the state of Wisconsin.
When you say the state of Wisconsin, who are you referring to?
Objection. Relevance.
Grounds.
Sustained.
Grounds for the sustain.
Not relevant.
Would you consider yourself to be the plaintiff in this matter?
Objection, relevance.
Grounds.
Sustained.
Grounds for the sustain.
Not relevant.
Are you aware of any plaintiff in this matter?
Objection.
Grounds. Ever had a conversation with the plaintiff at any time in this matter?
Objection, relevance.
Grounds. Have you ever had any phone conversations or personal interactions with the plaintiff in this matter?
Objection, vague.
Grounds. Are you aware of the identity of the plaintiff in this matter?
Objection.
Grounds.
Not relevant.
Grounds. Are you aware if there is a plaintiff in this matter?
Objection, relevance.
Grounds.
Sustained.
Grounds for the sustain.
On relevance grounds.
With all respect, Your Honor, the jury deserves to know this information. We're withholding important information from the jury. They deserve to know this.
The jury will disregard the statement made by Mr. Brooks as not being an accurate statement of the law. Next question.
So to the best of your knowledge, you're not aware of any plaintiff in this matter?
Objection.
Grounds.
Sustained. Mr. Brooks, you are hereby advised that if you do not move on to a new topic, I will close the cross-examination.
With all due respect, Your Honor, this is important information the jury deserves to know.
Mr. Brooks, ask a relevant question, please.
That holds a lot of relevance, Your Honor.
Mr. Brooks, one last opportunity.
No further questions.
I saw the vehicle strike my daughter. My daughter flew approximately 15 feet.
You said Kelsey flew approximately 15 feet?
Objection.
Your objection is noted. What was the objection?
That was already answered.
It's overruled. She was seeking clarification.
Can that be clarified?
No.
Is that a judicial determination, Your Honor?
Go ahead, Attorney
Were you
Basie.
able to see inside the vehicle?
I was. The eyes is what drew me in. We're completely wide open and made eye contact with the individual driving the vehicle.
So you looked eye to eye with the person who hit your daughter?
I did.
Did you see him in the courtroom today?
I do. He is
And
seated
I asked
in.
that Mr. Brooks take off his face mask.
He is seated at the table located over here. He's got a gray suit on, a blue shirt, and a tie.
Let the record reflect that witness has identified the defendant, Darrell Brooks.
Objection. I do not consent to being called that name, nor do I know any individual by that name, Your Honor.
The record will reflect that the witness has identified the defendant as the driver of the SUV that struck his daughter.
May my objection be noted for the record as well, Your Honor.
It's noted.
So you indicate that you were friends with Matt Harris and his family?
Objection. Relevancy
Overruled.
to this particular witness.
Overruled. It goes to context and background.
Grounds for that.
Context and background. It's also relevant.
And you say that Brindley was standing near Kelsey when Kelsey got hit?
Objection. Relevancy.
Overruled.
Did you see Brindley shortly after November 21st of last year?
Objection. Relevancy.
Overruled.
Did she have any type of medical dressing on her at that time?
Objection. Relevancy.
Overruled.
Grounds for that.
It's relevant.
Yes, she had a full cast on.
You may claim that you locked eyes with the driver of the vehicle. Would that be fair to say?
That is correct.
And approximately how far was the vehicle from you when you supposedly locked eyes?
20 feet.
Would it be fair to say that's about as far as I am from you now? Or was the vehicle further?
It was probably a little bit closer.
And what do you mean by a little bit closer?
Perhaps halfway, maybe 3/4 of the way.
What would be 3/4 of the way? Can you point about where?
Again, I estimated it about 20 feet. So
Would it be fair to say that halfway between you and I would not be an accurate statement of 20 feet?
Objection.
Grounds.
Overruled.
that's why I said it was about 3/4 of the way.
About what spot would it be? By this black, I guess, I don't know what that is. I don't know if that's a door or,
Electrical box.
excuse me, what is that?
It's an electrical box?
Would it be by this electrical box? Would it be this square directly next to the electrical box? Specifically, what would you say would be 3/4?
So the electrical box would be a good estimation of the distance. However, it was a little further to my left than where the electrical box was because it was coming at us at Morville.
So it would be a little further this way, coming back towards the table here.
Your Honor, I just ask that the defendant allow the witness to answer the question before he asks the next question.
In relation to where the electrical box is, probably approximately around like this general area right here.
Probably a little bit to the left of there.
Just so the record is clear, Mr. Brooks is standing up at his table. He's pointing pretty much directly in front of him, but to my left of the electrical box.
For the record, I'm a third party, Your Honor. Like that stated, for the record, I don't identify by that name or consent to being called that name, Your Honor.
Your lack of consent is noted. Next question, please.
Your Honor, just for the record, I don't think some of the jurors in the back can see the black electrical box.
Sure. Why don't we have our jurors stand? The jurors are all standing to take a look at where the electrical box is.
You would say from that general distance, you were able to clearly lock eyes with a vehicle that was passing you at a speed that you say was too fast?
The vehicle was not necessarily passing me, it was coming straight at me. And yes, I was able to lock eyes.
Do you recall what the driver was wearing?
I do not recall what the driver was wearing.
So it'd be fair to say that all you looked at was the eyes then, and not the entire face.
I saw the face. I did not see pants or make out any shirt or jacket.
I didn't ask about pants, but
The witness answered your question. Next question.
I would like to get to it, Your Honor. When the vehicle was coming towards you, it was turning away?
Yes, as the vehicle was coming directly towards our group, it did make a turn.
Why do you think the vehicle would have been turning away from you?
Objection.
Grounds.
Calls for speculation.
Grounds.
Sustained.
Grounds for the sustain, Your Honor.
Calls for speculation.
And you...
Mr. Brooks, sorry to interrupt. How much longer do you have? The only reason I asked, there is a tornado warning. I may be interrupting if another alert comes in. Are they going on? All right, we're going to take our lunch early then. Sorry for the interruption, Mr. Brooks.
What? Finish my question.
You will. My thoughts are as follows, is to have Mr. Knapp come back in and finish his cross-examination. And then frankly, given the severity of the weather that went through, is to break for the day. As is my practice, though, I will give the parties an opportunity to indicate whether they think differently.
We obviously have a full slate of witnesses here to go this afternoon. Some have traveled from like the Cudahy area. My only other suggestion would be take an extended break and let people make calls or even go home and check and come back at 3 o'clock or something. You could still work for a couple hours yet this afternoon.
I certainly would be open to maybe an extended break, but I'll hear from you, sir, if you have any position on that.
Yeah, I do have a position on that. I agree with your first assessment, Your Honor. Severity and weather, that can sometimes mess with equipment being, the trial being televised, that can possibly interrupt that. And you never know. Some people that may be key to this matter may not be able to come back after an extended break. I mean, there's no way to tell at this point. I do believe just for cautionary reasons would be wise to kind of break for the day and then reset tomorrow morning or whenever the court feels it's best.
Thank you.
State really quick for the record, Your Honor, I'm still waiting to obtain a filing.
I don't know what that means, sir, but I need to finish with the cross-examination.
Still no addressing of the subject matter jurisdiction, Your Honor.
I will not further be addressing it.
I just wanted to state that for the record. I'd like to apologize to the court. I'm not sure where I left off at. Did you recall any law enforcement being present at the Clinton Street?
Yes, there was a law enforcement officer. He helped save a lot of lives by pushing our children back.
Appreciate the extra commentary. Do you recall describing the driver as an African American male with long hair and facial hair?
I don't recall stating long hair.
I have the summary right here of the interview that you gave with law enforcement. Reading from that summary.
Your Honor, I'm going to object. Again, for the same reason I objected before.
With the reference to the statement that I referred to about the long hair, if I was able to show you, would it bring any recollection of what you may have said?
No. 11 months later, my recollection is that I made eye contact.
I'm not referring to that. I'm referring to the statement that reads, David, or yes, or wait, let me back up. Was there some confusion with your name in this report?
Not that I'm aware of.
It looks like the officer that was taking the report got a little confused on the name.
Mr. Brooks, you're providing a narrative, not a question.
Can I show the witness his statements? Maybe that may bring some recollection back of what was said.
I'll allow it. Give the statement to the bailiff.
But this witness says it does not refresh his recollection. I'm objecting to any questions after.
I understand.
Okay.
All right.
I object to that because
Hold on. Is there a particular paragraph you want to direct his attention to, Mr. Brooks?
the paragraph when he stated that the driver was an African American male with long hair.
All right, so, sir, just take a moment to review that. When you're done reviewing it, turn it over, and then Mr. Brooks will ask you some follow-up questions.
For the record, I don't consent to being called that name, Your Honor. Third party to the matter, Your Honor. Do you recall stating that the driver was an African American male with long hair?
I don't recall stating long hair, but that
Would it be fair to say that the summary that is in front of you states that's what you said?
It would be
Brown,
hearsay.
I'm stating directly what it says on the paperwork.
It's still hearsay, Mr. Brooks.
Is it fair to say that that's what
It's hearsay.
it's hearsay when it's right there for him to read?
Mr. Brooks, I direct your attention to the hearsay statute.
So it's not a fair.
Sustained.
Any reason why you wouldn't be able to see the driver's head?
my eyes were locked on a vehicle that was driving at a high rate of speed with the person driving the vehicle's eyes extremely wide.
You keep making reference to the eyes. So would it be fair to say then that because you were so fixated on the eyes, being so fixated on the eyes, would that in any way make it hard for you to see any other facial description?
I'm not sure your definition of hard. I'm stating what I saw.
Do you recall a skin complexion? Was it a dark skin complexion?
It was.
Would it be fair to say that who you identified today does not have a dark complexion?
Depends upon the definition of dark.
What is your definition of dark? Because in all fairness, you said dark skin.
Dark skin as present on my interaction with black males in the past.
So every black male that you've had an interaction with was dark skinned?
There's different complexions of dark, and it depends upon what your definition of dark is.
I'm asking your definition because you said dark skin.
I'm going to object to this line of questioning. The point has been made. This witness identified the defendant, Darrell Brooks, as a person driving the car. I think he's asked the question about dark skin. I think that this has been asked and answered.
Objection.
I'm going to sustain the objection.
May my objection be noted that I do not identify by that name, nor do I know anybody by that name. I don't consent to being called that name.
Noted.
Have you ever had any other interactions with any black males that were not considered dark-skinned by your definition?
I don't understand your question.
Have you had any previous interactions with African Americans that were not dark-skinned?
Objection to relevance.
Grounds.
Overruled. It relates to his identification.
I have interacted with black males before that have both lighter and darker skin tones.
Would it be fair to say that you didn't give that clarification when asked before?
I don't understand your question.
Would it be fair to say that you did not give that clarification when asked the same question before?
What clarification are you referring to?
You came to the conclusion that it was dark skin based on your interactions with African American males before.
The person that was driving the vehicle had a darker skin tone.
And just for clarification for the record, you did not see the vehicle strike anyone once it was past your location.
When it passed me, I saw the vehicle strike my daughter.
The location where you were at, near that intersection corner, I think it was.
So
once it was past that location is what I'm referring to.
Right. So after the vehicle struck my daughter and then past that location, I ran to my daughter as stated, and I did not see, other than the vehicle swerve back towards Main Street, the vehicle strike another human being.
So you did not see it, just for clarification, because that was a lot of commentary. For clarification for the record, you did not see it strike anyone else once it was past that location where you and your family were.
So, ladies and gentlemen of the jury, I have made a determination that today we are going to break early, just given all of the weather issues that happened earlier today. All right, thank you, everyone. We are in recess.